following news flash is brought to you by the Lone Star Lowdown, providing your daily bulletins for the commodities market. Today in history, news updates, and the inside scoop into the tides of the alternative. Markets for Wednesday, March 30th, 2016 are currently trading with gold at $1,227.66 an ounce, silver $15.20 an ounce, Texas crude $38.28 a barrel, and Bitcoin is currently sitting at about 412 U.S. currency. Today in history, the year 1870, Texas becomes the last Confederate state readmitted to the Union. Though the new state constitution wasn't approved until 1876, Texas, formerly part of the Confederacy, was admitted into the Union. Today in history. In recent news, the Federal Trade Commission announced today its efforts to crack down on fake cancer charities. The Cancer Fund of America, Cancer Support Services, and their leader, James Reynolds, including Reynolds Sr., will have to surrender an undisclosed amount of their personal assets as part of a settlement with the FTC and states. These purported nonprofits agreed to be permanently dissolved and their assets liquidated. Reynolds is also prohibited for life from managing charitable assets or being part of a charity's board or a trustee. Apparently, according to the FTC, of more than the $75 million the charities raised, a vast majority of these funds were going to the charities' organizers and their friends, with a measly percentage, less than 5%, going to actual patients and research. To make matters worse, an estimated 85% of the millions were spent on fundraising for the scheme itself. The charity's remaining assets will first go to pay the state's litigation fees, afterward to actual legitimate charities the state selects, though an FTC spokesman did state in an email that if there's any money left, it would probably be a very small amount. After more than 6 years in development, IBM's True North brain-inspired processor will be put to the test at the Lawrence Livermore National Lab. They purchased IBM's Neuromorphic System, a brain-inspired program based on the True North chip. California Research Lab is set to use it to help the National Nuclear Security Administration battle cybersecurity issues. Consuming just 2.5 watts of power, the same as a tablet computer, the neuromorphic system can process the equivalent of 16 million neurons and 4 billion synapses, containing only 16 of these True North chips. IBM chief scientist Dharmendra Modi stated that the delivery of this advanced computing platform represents a major milestone as we enter the next era of cognitive computing. This was Rick Rohde with your lowdown for March 30th, 2016.
You gonna do? Yeah. Bad boys, what you gonna do? What you gonna do when they come for you? Bad boys, what you gonna do? What you gonna do when they come for you? When you were 8 and you had bad treats, you go to school and learn the golden rule. So why are you acting like a bloody fool?
Okay, howdy. This is Randy Kelton, Rule of Law Radio on this Friday, the first day of April 2016. We're already a quarter of the way through another year. My mother warned me about this. I'm always kind of dismayed when a new month comes around, and it seems like it should only be a couple of weeks. But my mother warned me that this was going to get worse. Okay, tonight we intended to have a guest on. We have a lawyer in Wisconsin who is being attacked by the Office of Lawyer Regulation because she's been taking on these foreclosure issues with some really sophisticated arguments. But because the Office of Lawyer Regulation is jerking her around, she wasn't able to. So I'll hope to have her on soon. We don't have a guest on today, so I'm opening the phone lines. We'll keep them on all night. And since we have some time, there's one thing that I don't go through often, and I should, because this show is about how to take on public officials. And over several years of doing this show, we've worked out a set of methods that have turned out to be relatively effective. I was just in Weatherford, Texas, giving them a hard time the other day. The last time I was in Weatherford, Texas, they had someone in jail there for driving without a valid driver's license. Third offense, they put him in jail for 90 days. Now I have a woman in jail there, driving without a license, in jail for 90 days. And I looked in the record and found a motion in limine. And the prosecuting attorney in a motion in limine is a motion listing all of the things you can't say in court. They list it in the motion in limine and ask the judge to approve it. I have somewhere in my files, I have a wonderful motion in limine. It has everything in it. I found it in a criminal file. And I was in court when they were coming after me in Wise County a long time ago. And the judge he's annoyed having to go through this. And he come to this section, he said, and it asked the court to not allow the prosecutor to bring up anything about any hypnotic interviews. And the judge said, Mr. Kelter, were you hypnotized? Well, I don't know, Judge. You know how they make you forget that kind of stuff? Ask him. And the judge denied. He was a bit furious. But anyway, I found this motion in limine. And in there, they asked the judge to order the defendant not to raise any issue concerning the right to travel, not to bring up any statute or case law concerning the right to travel, as it was irrelevant to the case at bar. The judge approved it and approved the motion in limine, so that acted to deny the person in procedural due process. In the charge to the jury, the judge defined some terms. I'd have to pull it out and read it. But he made up his own definition to travel, to motor vehicle. Motor vehicle is anything that moves on the highway, anything that moves on the highway powered by a motor. Well, that's not the definition in the transportation code. So he made up a new definition that suited his purpose and gave that as an instruction to the jury. We're going to work this judge over. Anyway, we have a caller already, and it's Gary from Oklahoma. And I did not get to Eddie Craig on Oklahoma property taxes. My apologies, Gary. I wish you'd have sent me an email. You're on the air, Gary. I'm going to open a browser and see if I can find something on the subject of property taxes in Oklahoma. You there, Gary?
Yes. Hi, Randy.
Oklahoma. Okalohoma. Is that right? Yeah, Oklahoma.
Yeah.
Did you look up the property tax code for Oklahoma?
Yes, I have. And the more I read through it, the more confused I get. So.
Wait a minute. Move your mic down by your chin a little bit. It's distorting.
Okay. All right. Yes, I have read some of it. I really don't understand it.
Is there a section? Okay. Here I'm looking at property taxes, page 15. Is there a section in the property tax code for a payment options? Because generally, you said the other day that it had to all be paid in full by a certain date. Well, taxes code says that, but there's also options where someone is having trouble paying it. It's not the intent of the tax assessor collector to take your property. So there's a lot in there to give you opportunity. See, I'm looking here. This is not exactly the code. This is by the Taxpayer Education Series. What if you do not pay your taxes? The longer you allow your property taxes to go unpaid, the more expensive and risky it becomes for you. How far delinquent are you?
This will be the 4th year.
Okay, delinquent taxes are issued. Your property can be sold. Failure to pay your property taxes results in loss of the property. This is not the code, so it doesn't tell me what the code actually says. Okay, what does it say? How far delinquent do you have to be before the tax assessor can foreclose on the property?
I believe it's 36 months before notice.
Okay. Is there anything in the code concerning delinquency or payment options?
I hadn't come across one yet. Now I haven't finished reading all of the tax codes, so I haven't seen one as of yet.
And when is the tax sale supposed to come up?
June 14th.
Okay, you've got a little time. You've actually got enough time to file a civil action. And just for the record, okay, what is the procedure for challenging the amount you're being charged?
I'm not exactly sure on that yet. I've asked the court clerk, a few questions, and that's when she had told me that it needs to be paid in full. And what she failed to tell me was 2011 needs to be paid in full to get it off of the tax sale block.
Yeah, that one. Okay, yeah, the fourth year is the one that would have to be paid. How much is that?
With all it's about $3,500.
Wait, say that again. You kind of broke up.
About $3,500.
Okay. Yeah, you should be able to stop that. This is important. You got anything you can sell? Any way you could come up with at least a good portion of it?
Yeah, I've judged that. I've got about half of it now, so I'm on my way to getting it.
If you go down and give the tax assessor half of it, almost certainly he will stop the sale. You could offer him half of it on the condition that he stopped the sale and work out payment options. If he doesn't, then you can file suit. It only costs you a couple $100. And, okay, before you do anything, before I even say anything, I'm trying to look through here. These codes doesn't have a good table of contents, so I can't jump right to where I want to be. What you want to look at, okay, written estimate of revenue gain or loss, or written statement of recommendations, proposed tax law change. Now, I'm looking for assessments and how they do the assessments. One way to gain yourself some time is to sue them based on the assessed amount of the tax and claim that they're charging you too much. And they'll jump up and down and wave their arms and rail in righteous indignation, but you don't care. It'll buy you time. Yeah. But before you do that, you need to read the code twice. The first time you read the code, don't even try to understand it. Just cruise right through it. What that will do is give you referential index for the second time you read the code. When you go back through it a second time, all of these pieces will start fitting together. And I can guarantee you, if you read it twice, you'll understand it better than the tax assessor does. So, and then once you've done that, then you can file suit. It's really easy to file suit. I had a friend who was had eviction hearing coming up, and this is when I was first researching the foreclosure issue. He had an eviction hearing in 2 days, and he needed a lawsuit. I said, man, I'm still doing my research. He said, I don't have time for your research. He said, I got an eviction hearing coming up. I need something now. So I went on the internet and pulled down a bunch of junk and put it together and put a lawsuit caption on it, and he went down and filed it and stopped the eviction. The other side got a copy of it, and they sent a motion to dismiss to the court and effectively said, Your Honor, you should dismiss this case because it's a bunch of crap. And the judge, he read it, and he agreed it's a bunch of crap. He ordered my friend to file an amended. So he filed it amended. Now, that took about 90 days. So he filed the amended. We'll be right back. We're about to go to break. We'll pick this up on the other side. I almost ran off the cliff again. This is Randy Kelton, Rule of Law Radio. Our call-in number, 512-646-1984. Give us a call. And this is the end of our fundraiser, so go to our sponsors and help us stay on the air.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
On the edge of a hole, inside a deep dark bowl, I'm always on the lookout for something to soothe my soul. So I sit back and I watch the evidence unfold, and I
Okay, we are back. Randy Calton, Real Law Radio. I'm looking through the tax code here, but I'm not sure I'm in the right place. There seems to be a general tax office. I don't see a county assessor collector. I do see where you can post a bond. Any bond required to be filed to protect the state of Oklahoma under this article or any state tax law must be approved. Are there any bonds required for property taxes in Oklahoma?
Not that I know of.
Well, the first thing is considering the value of your property and how relatively little you owe on it, you really need to scour these codes and study them. You could get a lawyer, but the lawyer would just charge you a fortune and then throw you under the bus anyway. First thing I suggest, and at this point it's the only thing I can suggest, is that you get the tax code and read the whole thing twice. Once you've read it twice, you'll have a real good understanding of how all the pieces fit together. And then all you have to do is call them on an issue. Public officials never do it right. They just can't help themselves. They never do it right. They do it the way officials have been doing it. And if the code doesn't match what they're doing, they assume there must be some law or case law or regulation or exemption or something they don't know about. Because if this was wrong, everybody wouldn't be doing it. So, in short, they just do what they've always been doing. We don't care what the law says. So, when you read the law and bring it back to them, now they start hopping and jumping. And all you have to do is find them violating one law. Primarily, look at how they assess the amount of taxes. Keep in mind, they're collecting money to pay salaries. So, they have an incentive to collect all the money they can. So if there's a matter of a judgment call on whether something should be assessed, they're going to go for the assessment rather than lowering their income. I mean, it's just natural. And when nobody challenges it, they get used to doing it. And then they think it's how it's supposed to be done. Then somebody like you comes along and hammers them with it. If you can find some procedure they're doing that has the effect of increasing their revenue, now you can pull out the private attorney general card. You can sue in the capacity of a private attorney general. Now, there's a lot of stuff in the patriot community about becoming a private attorney general. Well, you can't become a private attorney general. A private attorney general suit is what the courts have named a particular type of suit that they allow. Let's say that the tax assessor is assessing an extra $100 on every property in the county. Well, $100, you're going to sue for $100. It's going to cost you several thousand to file and prosecute the suit. So it's not worth it. However, because of that, because the law leaves these gaps, you can sue in your behalf and in the behalf of others similarly situated. And you can collect for yourself and for those others, for the harm to the others. That way, it allows your suit to have a potential payoff of enough to make it worth your paying the attorney fees and the filing fees and going to all the trouble that it would take to right this wrong. And really, when you get right down to it, it's not that hard to do a lawsuit, especially if you're pro se. Yeah, I know. There's some purists out there that are going to say, oh, well, you shouldn't file a suit unless you have a reasonable expectation of winning. And you should never file a suit just to harass them. Yeah, I know that. But in the real world we live in, it's all about the money in the end. When you file suit against the tax assessor collector, it's going to cost him a whole lot more than you owe to fight you. Mm-hmm. Yeah. And there's one other really neat little thing that comes with it. Prosecuting attorneys are usually not the sharpest knives in the drawer. If they were the sharpest knife in the drawer, they'd be out there making the big bucks. But they get out of law school, and if a firm don't pick them up, or they're having trouble building a clientele, then they go down and run for prosecuting attorney, or they go to work for the prosecutor's office. And as a prosecutor, they don't have to do much. All they have to do is make deals, because 99.6% of all crimes across the board wind up with a deal and a plea of guilty. So they don't have to practice law. All they have to do is get good at making deals. Then, when the prosecuting attorney, which in your case would be the county attorney, in a lawsuit against the county, the prosecuting attorney becomes the lawyer for the county. When he's a lawyer for the county, he is not a prosecutor and has zero immunity from suit. So if he stubs his little toe, you bang him with a lawsuit. Now they get real excited. The prosecutor is going to get really excited because a lawsuit against him will drive their bond rating through the roof. And the bonding company, essentially that's the county's insurance company, they're going to get really unhappy. And the lawyer himself. If he leaves the prosecutor's office, he won't be able to get malpractice insurance. It's not about the law. It's not about the right. It's not about the right of things. It's all about the politics.
Well,
so
what I understand is they're not allowed to charge us direct taxes, which property tax falls under that guise.
Wait a minute. Hold on. Yeah, move the mic a little bit away from your face. It's distorting.
The property tax is considered a direct tax, which we're not supposed to have a direct tax. There's not supposed to be a law for direct tax.
Oh, no. You're not going to win that fight.
Okay.
You'll get that one. That one they will dismiss immediately. And you'll file an appeal in the Court of Appeals to get it, and they will dismiss immediately. It is the natural tendency to try to win your case based on the rule of law. Unfortunately, it doesn't work that way. One of the things you have to look at is, even if you're dead bang right, if the court rules in your favor, then that will have the effect of rendering void all the property tax codes and will bankrupt the state of Oklahoma. What do you think the likelihood of that is? Yeah. Okay. The politics is that we want to look for a claim that if they rule against you, they damage the corpus juris, the body of law. Now, this trial judge, he don't much care about the body of law. He just cares about the politics of the moment. He cares about satisfying the tax assessor collector and the people in the county. The Court of Appeals, they have a whole other attitude. They don't want to render a ruling another lawyer can use that'll disrupt the body of law. Hang on, I'll explain this better on the other side, and we'll be right back.
The Chicago Marathon is no tiptoe through the tulips, but a pregnant woman overdue with her second child ran the whole race before going into labor. I'm Dr. Catherine Albrecht, back with the amazing story of the marathon mom next.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Amber Miller, a 27-year-old mom from suburban Chicago, gives new meaning to the word endurance. Miller was pregnant and 3 weeks overdue at the start of the city's marathon. She'd run 7 times before, including once while pregnant with her first child, so she figured, what the heck, and planned to run only half the course. But when she got started, she just kept going, finishing the entire 26 miles in just over 6 hours. Then at the finish line, she had a more urgent race to run to the hospital, where she gave birth to a healthy 7-pound baby girl. Phew, I bet that was a relief. I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
You're listening to the Logos Radio Network at logosradionetwork.com.
Yeah, I got a warrant, and I'm going to serve them to the head government them.
Prosecute him. Okay. All set. The questions are ready.
Okay, we are back. Randy Kelton, Rule of Law Radio, and we're talking to Gary in Oklahoma. Gary, we're having a little difficulty. My producer says you're talking too soft, but when you talk loud, your mic is distorting. So try moving your mic down so it's not in front of your mouth and talk a little bit louder. So you put it right by your chin. Maybe it'll pick up better without distorting. Okay.
Talking about curious.
Okay, I'm talking about finding a way to sting them and just to stop them and hold them. If they're violating a policy, or if you can show that it appears that they're violating a policy, if they're assessing the tax in a way that doesn't appear to be completely within their guidelines, and you can always find something like that, then you sting them. You file a suit against them and ask for an injunction against the collection of the tax, because if they're assessing more tax than you actually owe, that contributes to your inability to pay. So now they become partially liable for your inability to pay. And you ask for an injunction against the tax assessor so that he doesn't collect any legal tax. And almost even without an injunction, when you file suit against them, they'll stop their collection process. Okay. And then this buys you time to recover so you can begin to pay the tax back. And almost certainly, because it costs them so much to fight you, they're likely to come to the table and make a deal for a reduced payoff. Okay. Heck, it's only $3,500. It's going to cost them more than that just to answer it.
Absolutely. Okay.
Okay. Lawyers would say, "Oh, it's not nice to do that to the poor tax assessor collector. Yeah, life is tough."
I'm not worried about being nice. That's for certain. Yeah.
Yeah. He's not going to be nice when he comes after you. So let's take it back to him, and you keep him honest. Okay. I hope that helps. But go through the code, read the code, and then call us back next week. And then we'll talk about what you find in there. I think you will be pleasantly surprised at what you find in there.
Okay. Yeah, the assessment.
Okay. Thank you, Gary.
Okay. Yeah, we're good.
Okay. Wait, did you have another question?
No, I was just going to make 2 points. For some of the information I did find out. Every 4 years they're supposed to assess. The person's supposed to physically come out and assess. However, I've been here for 16 years in this house, and I've never seen any paperwork for the assessment. And also go off of the...
you mean the tax assessor collectors never knocked on your door and asked to look around?
Never.
I just had one do that to me recently. He said, "I understand you're doing some work in the house. And you mind if I come in and look?" I said, "Get out of here." "Oh, Mr. Kelton, we need to reassess it." "Yes, yeah, I know you do, but I don't want you to." And I told him I wasn't finished yet. When I'm finished with the work, they're going to want to come and reassess it. So they love my assessment. So if you've never seen them, then they're just doing an average tax. And if the code says they're supposed to do an assessment, that's one you can sting them good. Because now they're looking at having to go out and actually assess every property. That's going to cost them a lot of money.
Yes. It's to their duty.
This is great.
Yeah. After all this is said and done, I found out though that if you own your allodial title, then you can get taken off of a tax roll.
That's a lot. That's somewhat different. We had a guy out of New York, and what he did is he sent a letter to the tax assessor collector. He sent a letter to the county commissioner's court and asked the court if the county or the state had a claim against his property. And they sent back a letter saying, no, they don't. They will in your case, they'll say this tax lien. Let me explain how this works. Originally, the state of Oklahoma gave away a whole bunch of land grants. But part of it is that they didn't, in the Great Land Rush, that was where they gave away a bunch of land, but the rest of it they sold. And when they sold the property to someone, they took a lien against the property because they most often sold the property on time because nobody had any money to pay for it all at once. So they took a lien against the property in the form of a title. The deed to your property is a lien. The warranty deed, that's a lien that the state has against your property. And once it was paid off, that title was supposed to have been eliminated, and you go back to when you're a loyal title. But nobody did that. The only time they can tax you is if the state holds a claim against the property. So you go in and ask the county tax assessor collector if the state has a claim against your property. And if your taxes are all paid up, they're going to say no, and you need them to say no. And once they say no, then you send a letter to the tax assessor collector stating that the state has no claim against your property to move you to the private rolls. There's a section for private property and state claimed property, and that takes you off the tax rolls. A loyal title or getting off the tax rolls has other consequences. Do you live in a municipality?
Yeah.
Okay, if you're in town, that creates other problems. If you bring forward your loyal title and get off the tax rolls, you're no longer paying for police and fire protection. They won't be allowed to protect you. If your house catches on fire, all the fire department can do is keep the houses around you from catching on fire. They can't put yours out because you're not under contract with them. If you call the police, they can't come to your property and assist you because you're not under contract with them. It's all under contract. So a loyal title is maybe an option. It's a greater option in Texas because we have our own land board, and everybody else goes through the BLM, Bureau of Land Management for the U.S. Texas has its own. So it's more difficult through the BLM, but even if you did, it has consequences. Much more difficult than just suing them and saying, okay, guys, you've been bad boys, but let's make a deal. You clear up all my back taxes and I'll drop my suit against you. Otherwise, you might lose, and now you're going to have to go out and assess every single property in the county. It's your call, guys.
Yeah.
Okay, but do your homework. Make sure you got all your ducks in a row. Read the code twice. And read the whole thing.
Okay,
because they got hidden stuff in there. And once you've read it and you know what's there, then they can't pull any fast ones on you.
All right. Well, I appreciate your time and your information. You have a great evening.
Okay. Thank you, Gary. Okay, now we're going to go to Joseph in New York. Hello, Joseph. I understand you also have a tax issue.
Yes, I do.
Wait, we got 50 seconds, so state it quickly and give me about 15 for an outro.
Okay. It has to do with a hearing that was held or supposedly held to transfer, the...
Wait a minute. This is not going to get done in 30 seconds. No. Hold on. Okay, we're about to go to break. This is Randy Kelton, Rude Law Radio, and this is the last. This is the end of our fundraiser, and we haven't collected near enough. So check out our sponsors. We'd appreciate any help we can get. If you patronize our sponsors, that'll help support this show. We'll be right back.
Easy.
For. When I'm hungry, I like to know just what I'm fishing for. I ain't asking for much.
Okay, we are back. Randy Kelton, Real Law Radio, and we're talking to Joseph in New York. Okay, Joe.
Well,
where were we?
I wanted to bring up one thing before I got to my question. Back in the 1980s, a fellow acquired a loyal title in my village to his house, and several years later, his house caught on fire. And the fire department did exactly as you said. They just got to make sure everybody was safe and allowed his house to burn down. He sued the village and won. I'm not sure, the particulars of the case.
Even though he wasn't under contract with them.
This is correct.
Okay, I would have to see the suit. There's probably some statutory provision that made it the duty of the fire department to protect the safety of all the citizens without regard. I'm not sure how that works. What we suggest for people who do an loyal title is they go to the police department and the fire department and write their own contract with them.
Yeah.
But when you do that, there goes a lot of the advantage of the getting off the tax rolls.
Yeah.
Because you wind up having to pay anyway, so I don't know how much advantage it is. But that is an interesting story. It'd be interesting to find out how he managed to win the suit.
Yeah.
Because it may be that the fire department doesn't have to be in contract with him for him to have a right to the protection. But I wouldn't think so, because originally we didn't have fire departments. Right. We had volunteers. So who pays the fire department? If you're in a municipality, the municipality pays the fire department. So the fire department is, they are a part of this municipal corporation.
Correct, yes.
If you have a loyal title, then you would be presumed not to be in contract with the city unless you did something else to bring you in contract with the city.
Yeah.
So if he's contracting for city services, water, if the city supplies electricity, then electricity, garbage pickup, I would think that if he is in the municipality and he uses the public thoroughfares, then he's likely to have a legal obligation to pay for that usage. And even if he doesn't, by the usage of it, he would gain a benefit and thereby be in an adhesion contract with the city.
Correct, yes.
Yeah. I'm not sure how that would work. In saying that, then we go back to the right to travel. The public thoroughfares are public thoroughfares and not just thoroughfares usable by those who are in contract. So technically he should be able to use all the thoroughfares anyway, especially if they use any federal funds, because an loyal title doesn't get him around federal taxes, so he would be presumed to be in some kind of contract with the feds, and that would give him access to all the thoroughfares. I'm just kind of bouncing through all the things I can think of that would likely influence this. But I don't understand how they can hold the fire department responsible unless there's a specific statute that orders them to put out a fire no matter what.
Well, I remember it created an awful ruckus. I mean, there was a lot of... there's a lot of articles, in the various newspapers about it, because, the public officials were up in arms.
And I understand it. It's reasonable. You don't want to pay the taxes, but you want to hold us responsible for providing your services anyway.
Yes.
So if I'm the guy next door, I'm not going to be happy about that.
Right.
So that is an interesting issue. Okay, let's go to your issue.
Real digging to look that up. Oh, okay. My issue is I decided to pick a fight with the tax department, and
guy after my own heart.
Well,
that's the kind of fight to have.
Well, sometimes I'm a little braver than I am smart. But I got involved in taking on the tax department, and then some other things came up, and it got in the way of me pursuing it in a timely fashion. So, fortunately, when they seized my property, a friend of mine bought it for me. So now he holds title to not title. He has what's the other thing?
Tax lien. Is it tax lien against?
Yeah. So he, presently, he has. Possession of my home, even though I still live here. And my initial attack was going to be I wanted to see the transfer document. And so I went to the court and I asked them, I want to see, I want copies of, the hearing. Well, they couldn't find any hearing. They told me to go to the county records. So I went there. They didn't have any copy of the hearing. They told me, well, the Treasury Department would initially acquire that. They probably still got it. So I went there and they didn't have it. All they had was a threat that they were going to do it. So now I'm sitting there, well, apparently.
Did you give them a written request?
Not yet, because that's just what I'm about to do.
Okay.
I went to my files, and they pulled my files in both the Records Department and in the Treasury Department, and there's just nothing in them. And I was like, well, how the heck did you guys get the authority to sell my property if this didn't get transferred? So now my question to you is, I'm very simple for you, is what's my best next move?
Okay. For in the future, I want to back you up a little bit. The first time you ask someone for documents and they say they don't have them, you take out a piece of paper and give them a written request. I did this recently in Hayes County, and the clerk got my written request and said, well, Mr. Kelton, I just told you we don't have that. I said, I know that. But now I have requested the records in writing, and under the Open Records Act, I have a right to a response in writing. So I just need you to write me a response that says we have no records responsive to your request. And she did. Now I can document. On this day, at this time, they didn't have them. Tell me you recorded these guys when you talked to them.
No, it was initially I was just running around doing it.
Okay.
And
okay. This is what I would like you to do. Take the phone and beat yourself around the eyes and the ears. Okay. Now go back to each department. And wait a minute. Hold on. Do you know which department should have the records?
Yeah, the Records Department should have the records.
Then give the Records Department a request. And that's good because for the most part, they just keep the records. People send them the records. They store the records. They don't have to go out and get the records. If you don't send me the records, I don't care. I don't keep what I don't get. So they'll just go in there and look and say, oh, well, it's not here. Nobody sent it to us. And they're finished. So they won't go scour the county looking for them. So you file with them, request them. And if they say they don't have them, ask them to do that in writing. And you can tell them it's okay to do emails because emails are something that you can track and it's nice and quick. So give them a request for these documents and notify them they can respond in writing or by email. Once you get a confirmation that they don't have it, now you can go after the tax sale. Is there a deed filed in the record, a tax lien filed in the record?
Yes.
Okay. Does the lien have your friend's name on it?
Yes.
Okay. Then you go in and file against that lien and sue your friend. And then have your friend sue the county for doing a bogus sale to him. And if they have to undo the sale, now your friend loses the benefit of the bargain. And he gets to sue him based on his loss of the benefit of the bargain. We'll talk a little bit more about that on the other side. That should be a lot of fun. Okay, and one thing, I've got about 40 seconds. I want to mention one of our producers suggested we should make up some bumper stickers. So I'm going to make up a bunch of bumper stickers. And Root of Law Radio, I listen to Root of Law Radio. And we're going to make those, we're going to put them up for sale for like $5 or $10. Maybe we'll produce a little income for the station. And Root of Law Radio is getting kind of known, especially around Texas. So it might actually get you out of a ticket. Okay, about to go to break. Call in number 512-646-1984. We'll be right back.
It's all according to the will of the Almighty. I read his book and it says he cares not for the unsightly. These warmongers come by that term rightly.
Okay, we are back. Randy Kelton, Rule of Law Radio, and we're talking to Joseph in New York. Okay, Joe.
Well, I guess the one thing I would ask is, would there be a way I could proceed that would be just as effective that wouldn't involve me suing my friend? I'd hate to have, make...
No, that's not it.
Not my friend anymore.
You see,
what?
No. It's kind of a friendly suit. Your friend is not at fault at all.
Correct.
You don't sue him for damages. You sue him for declaratory judgment. So in suing him, you give him a claim against the city. So
all right, so I don't harm him.
No, this is a friendly suit.
Oh, okay.
He don't have a claim unless he's been harmed. Once you sue him, now he's been harmed. And you first do your homework and make sure of what they're supposed to have. Make sure exactly what the steps are supposed to be. Then you go in and sharpshoot them with requests for documentation that should occur in the process of doing these steps. It's better if you can do this in a way that doesn't send up a red flag. I went in to Weatherford, Texas the other day, and I asked to see a list of all of the attorneys on the attorney wheel, a list of all vouchers for payment to attorneys on the attorney wheel, and something else. And I really didn't care about that. And then I went in and requested a bunch of documents, a bunch of different cases. So they don't know what I'm looking for. What I'm looking for. Oh, and one other request I put in was all documents collected, assembled, maintained by the department that are referenced by Article 17.30 Texas Code of Criminal Procedure. And they're not even going to know what that is. After an examining trial, the magistrate is supposed to seal all the documents had in the hearing, cause his name to be written across the seal of the envelope, forward to the clerk's court of jurisdiction. They never, ever do that. So I asked for all this other stuff and just stick that one in there. There has to be an order under 16.17 in the court record, and there's not one there. I don't want them to figure that out. When I ask for those records, that's one of the ones I'm looking for, but I don't want them to know what I'm looking for. So I ask for things in a way that it's not clear what I'm looking for, so they don't know how to fix it. So when you go in and ask for records, don't just ask for what you want. Ask for some other stuff around it. So it's not clear where you're headed. That way they don't get fair warning. This is not ordinary civil behavior. This is legal civil behavior. And in legal civil behavior, bushwhack is perfectly acceptable. No fair warnings. So go in and ask them for a bunch of junk. And you may actually get them to screw up on giving you all the junk, because then you get a claim against them. But the main one is, all the steps in the procedure. Look for the documents they have to file, the notices they have to give, and any document that's missing in the process that would make this sale technically improper, so that they have to go back and redo the sale. Well, they can't just undo the sale and then sell it back to your friend. If they undo the sale, they have to hold another auction.
Right.
Even if your friend buys it back, he had a right to that purchase. He purchased the property, and he had a right to the benefit of that bargain. And when they undo the sale, he's lost the benefit of that bargain. Now he has to come back and make the bargain again. So now he gets to sue for what he would have made on the deal that the city screwed up for him. Does that make sense?
Yes.
So you sue, once you get all your ducks in a row, you sue the county and you sue your friend, and your friend jumps up and down, rails and writes his indignation, and he sues the county himself. Mm-hmm. Now they got two guys coming at him.
Well, yeah, he was kind of hoping that we could sue him together, because I was talking about filing a suit in the Sunset, because, I'm really not all that attached to this house. There's just things that we were kicking around.
Well, that would be great fun, because he has a good quality claim. this sets them up so he gets a claim all on his own. And then they're still dealing with the property. So
yeah,
you both of you sue you sue him, he sues them. They get you to drop your suit against him, so he'll drop his suit against them, and you get them to drop all their taxes against you.
Really? Yeah.
It's going to cost them more to fight you, even if they win in the end. The problem they have is with your friend.
Yeah.
Is what you have sued him because of the improprieties of the county. Doesn't matter if the county can make what they did right. He got sued, and he had to answer the suit. And his lawyer was really, really expensive. and he had to go to counseling because now he has post-mortem depression. I don't know.
Well, yeah, he's been traumatized. And
poor guy's just made him a wreck.
Yeah.
Now,
his wife won't talk to him. And
she's going to divorce him. Oh, this is awful.
He's got to do his own cooking now.
Say, guys, see, now his life's in jeopardy.
Yeah.
But we need. This sounds like it's funny and stuff, but it's not. This is serious business. They are public servants. You are the master of those servants. It is your duty to police your public servants. Mm-hmm. This is not just for fun or money.
I got into this because of all of the crazy well, if you want to call them laws, that have been getting passed in the last decade. They're really to strip us of so many rights, and I was just getting more and more angry about it. And I wanted to find a positive way to fight back. I didn't really want to get involved in civil disobedience, and I really don't want to.
One of the things that is absolutely consistent with public officials, they just cannot bring themselves to do it right.
Yeah,
they just can't. And the more you sting them, it seems the dumber they get. And the one thing they hate, Texas, they hate to see me coming. My district attorney in the county I live in hates me. My daughter, she married a relatively prominent family in the county, and they're politically well connected. And it just infuriates my daughter that the district judge absolutely hates me. And the reason he hates me is I've taken his own code and crammed it right down his throat. The 21st of this month, I will file first-degree felony aggravated assault charges against him directly with the grand jury. The prosecuting attorney has already said he will stand aside. So you want to play hardball with me, Bubba? I will introduce you to the deep end of the pool. I'm taking him and the Texas Ranger both. But I'm dead point on law. Okay, it's really nitpicking law. Okay, I got that part. I cut this really fine legal hair, but I cut it. And he's going to have to stand and answer. Next time I go to him, and for the purpose of asserting a right, he's not going to threaten to have me arrested and have an armed bailiff put his hand on my arm. We see how that works out for you. This is our job.
Right.
They're the servants, we're the masters. Better to hold them to the fine letter of a tiny little law than let them get out of hand till they do something really outrageous that can cost them their career. So sting them over something minor. And it's more powerful when you sting. You sting these guys this way and they realize you set them up. That makes it 10 times better. When I pulled that hearing aid gambit on a justice of the peace in Tarrant County, that was I was just screwing around. And it turned out to be one of the most powerful things I did because I set the judge up, told him I didn't have a hearing aid, and I lied to him. I had it in my pocket. And he wouldn't turn the sound up in the courtroom. So when I was done, I asked the bailiff to arrest him for not providing me accommodation under the Americans with Disabilities Act. And the bailiff said, well, Mr. Kelton, why didn't you tell the judge about the Americans with Disabilities Act? Heck, if I'd have done that, he might have turned the sound up. The bailiff stood there a minute like it took a while to process what I just told him. And his big grin started across his face, and he said, well, you set him up. I said, yeah, I did. He was a sucker for that one, wasn't he? That got around the county in a heartbeat. Now when I walk in, the word is, that dirty, rotten scoundrel, he's trying to get you to do something so he can try to get you arrested or take you to the grand jury. That's right, I am. So don't screw with me. Just follow the rules. You don't have a problem with me. I just had a sheriff's deputy tell me that I couldn't see a criminal record unless it was my case. Says, is that right? Oh, yeah, you have to either be a lawyer or you have to be the accused. You can't see those records. Oh, do you have a supervisor? Well, yes, I do. Get him. Supervisor comes out. What can I do for you? I need you to arrest him. And he's down there looking at me, what? And he said, why? Well, he told me I couldn't see a criminal record unless I was the accused. And he said, well, what's wrong with that? It's a lie. That's what's wrong with it. And he denied me the full and free access to enjoyment right under 39.03 Penal Codes, Class A misdemeanor. I want you to arrest him. Oh, that was so much fun. Hang on, Randy Kelton, Rule of Law Radio. We'll be right back.
This is the Logos Radio Network.
Ain't gonna blind me.
Okay, we are back. Randy Kelton, Rule of Law Radio, and we're talking to Joe in New York. And it's perfectly all right to have fun at this, but it is really serious. We are the masters, they are the servants, and we ask the police to police us, and we owe it to the police to police them. And that's why when you said you picked this fight, that I said you're a man after my own heart, because those are the best fights to have, is the ones you picked. And you're the most effective when you pick the fight. But pick them carefully and make sure you do your homework first. And that's part of our job on this show, to try to give people an idea of what they need to look for and what the shenanigans these shysters are going to pull will be. And like we were talking about earlier, when you sue the tax assessor collector, the county attorney is going to represent him. That's when it really gets fun. Wait till you start bar-grieving the tax assessor. And the expectation is when you go in the door that the judge is going to rule against you out of hand at every turn. So you start filing judicial conduct complaints against him. You're in New York. And as far as I can tell, New York may be the only state that actually has a functional judicial conduct commission.
Yeah, it works real well. I've used it.
Yeah. I heard of a case. I had a friend of mine. Actually, he used to co-host a show with me, Chris Campanella. He filed criminal complaints against a mayor and a sheriff with a magistrate, and they went in and arrested him. Oh. The mayor and the sheriff both. Got a case law about a judge who didn't get someone who was fighting a case, and the judge wouldn't put it on for trial. And after a year, the guy filed a judicial conduct complaint, and they came in and sanctioned the judge for not maintaining his calendar. And that was astounding, because normally, in Texas, you can't get a judge sanctioned unless he shoots half a dozen people. And then they're reluctant. And here, just for not maintaining his calendar in New York, they sanctioned the judge. So your judge is going to be afraid of your judicial conduct commission. So great opportunity. You'll also make it so that you won't get any tickets. A sheriff's deputy came to me a while back and said, what did you do to the sheriff? I said, well, I haven't done anything to him lately. Why? He said, well, we had roll call this morning, and he asked who here knew Randy Kelton. About half of us raised our hand, and he said, look, you are not to stop him. You are not to cite him, and whatever you do, don't put that SOB in my jail. What? What? He don't send me a Christmas card or anything. But that's what happens. They don't want anything to do with you. And they need at least one citizen, preferably half a dozen citizens, that they don't want to touch with a 10-foot pole. so that the judge understands, and this is my stated intent for this show. If you don't know where you're going, good chance you're going to wind up somewhere else. When you go after these guys, you need to sit down and decide for yourself at the end of the day, what will be an equitable outcome for me so that I know when I've won. For me, my purpose is to put every judge in the country in a position such that when they step up behind the they step up behind the bench and look out across the bar at the gallery, I want them wondering, which one of those scoundrels sitting out there waiting for me to do something so he can run down to the grand jury and try to get me indicted, or go to the conduct commission trying to get me thrown off the bench.
Yes.
When they're thinking that, they're going to be careful. I don't want the judge just looking at the defendant and the plaintiff. I want him looking out at the gallery. And when you come in and start setting them up, bushwhacking them, that's when they start watching the gallery. When I go into a court now in Dallas or Fort Worth, they know immediately. A friend of mine called me. A guy he knew went into court in Southlake, Texas, little municipality that's halfway between Dallas and Fort Worth, with a turban on. He was Indian. And they asked him to take it off, and he said he couldn't. It was a religious thing. So they threw him out of the court. Said the bailiff come out and asked him, "Are you Randy Kelton?" And he was telling David this, and he said, "What were they talking about? Who is Randy Kelton?" And David said, "Oh, yeah, I know who Randy Kelton is." I'd never been into Southlake's court. But they knew it. They knew about me. Somebody has given them a hard time, and they just assumed it was me. So it is really powerful when you take these guys on and you do it with their own law. So I could not be more pleased with you, Joseph. And it looks like you got a real good shot at them. Primary thing, do your homework.
I'll keep. I've been doing my homework on this for a little over a year now, and I've gotten involved in some vehicle traffic law cases, and I've done real well with those for some friends of mine, and that's where I got involved with bar grievances and judicial conduct complaints. And boy, does that ever get a case dropped quick.
Okay, yeah, that shouldn't be as much fun it is. You ought to be ashamed of yourself for enjoying that so much. I know I'm terribly ashamed of myself.
I sulk all the time. But I had a case. A friend of mine was driving taxi, and this cop gave him a ride on red at midnight. When the sign clearly says between 8 a.m. and 5 p.m. So I wrote up a little brief, attacking what the cop did and demanded that he be arrested and everything. I brought it to court. And, defending my friend. And the judge and I got in a big fight about, my right to defend my friend. We got in a screaming match. He kept telling me he was going to arrest me, and I kept telling him, well, here I am, go for it. And the prosecutor comes running down the aisle, yelling to dismiss the case. I'd given the prosecutor all of my paperwork, prior to sitting down, so he had a chance to look it over. And, he got the judge to dismiss it. And the strangest thing, he patted me on the back and he shook my hand. He told me I'd done a wonderful job defending my friend. The judge had some kind of an emotional meltdown. He had to leave the bench. And then he quit the bench. And the cop got fired.
Oh, wonderful.
I never even got to litigate the case. I never got to say a thing.
Well, I had a problem in Hazel, Texas, over a speeding issue, and the judge said, "Is the prosecution ready?" And the prosecutor said, "No, Your Honor, the prosecution is not ready. Case dismissed." I object. "Mr. Kelton, you can't object to me dismissing the case." So we sure can, Judge. We were just about to get to the fun part. Get out of my court. If we can get more people like you, we will start having fair and proper courts. I know people complain about our public officials, but frankly, it's not their fault. It's our fault.
No, that's true.
And we haven't held them to a fine line on rule of law. To quote Romeo and Juliet, we have winked at their discords. The first time they stepped across one of our legal lines, we didn't rail in righteous indignation. So through a series of seemingly minor adjustments toward administrative convenience and adjudicative expediency, they have gotten so far outside the rule of law that when you read the code and compare it to the practice, you'll think you've stepped through the looking glass. You'll wonder, how can it be so messed up? And it got this messed up because we were not diligent. So, thank you, Joseph, for being diligent. Do you have anything else for us?
Not today.
Okay, and I'm having too much fun talking with you. Okay, keep it up, Joseph, and keep us appraised of how this goes. Randy Kelton, Rule of Law Radio. We'll be right back.
Are you having guilty thoughts? They could land you in jail. Neuroforensic brain scans are being used to prove guilt in India, and they could be coming to a courtroom near you. I'm Dr. Catherine Albrecht, and I'll tell you more in just a moment.
Your search engine is watching you, recording all your searches and creating a massive database of your personal information. That's creepy, but it doesn't have to be that way. Startpage.com is the world's most private search engine. Startpage doesn't store your IP address, make a record of your searches, or use tracking cookies, and they're third-party certified. If you don't like Big Brother spying on you, start over with Startpage. Great search results and total privacy. Startpage.com, the world's most private search engine.
If you're charged with murder in India, you could confess without saying a word. Their courts use brainwave technology to read defendants' minds and place them at the scene of the crime. The accused is fitted with a wired cap hooked to an EEG machine. Investigators then read statements about the crime and document the defendant's brain response. They claim the system is foolproof since it measures electrical activity sparked by knowledge in the brain. While the U.S. does not yet allow brainwave evidence, experts predict it's just a matter of time. Defense attorneys are petitioning for its use in American courts to exonerate convicted criminals. I'm Dr. Catherine Albrecht. More news and information at CatherineAlbrecht.com.
Trails.
Looking for some truth? You found it. LogosRadioNetwork.com.
Okay, we are back. Randy Kelton, Rule of Law Radio, and we're going to Chris in Pennsylvania. Hello, Chris.
Hello, Randy.
So how's it going with your foreclosure issue? For those of you who don't know, Chris he filed bankruptcy, claimed the property as unsecured. The bankruptcy court, what do you call it? Discharged. I keep losing that term. Discharged the debt, and now the lender is coming back trying to sue for foreclosure based on the deed of trust. So where are we with that case?
Well, we spoke last about the fact that they put in a summary judgment, and our attorney countered with a response that the bank actually didn't take the assignment of the mortgage. They took, since we built the home, they took an assignment of the construction loan, which was paid off. So in essence, they took no assignment of the mortgage, and now the judge is giving the bank the opportunity to make a statement as to why we're not entitled to relief based on that. And my question to you,
I think the legal terminology for that is that was an oops.
Right.
They should have paid more attention. This is, people listening to this, they think that is really an odd thing that they would make that kind of mistake. Well, it may be odd, but it's not uncommon. If you go to the county recorder and you look at what's in the public record, you will not believe the garbage you find in there. You would think that when the bank invests $200,000, $300,000, $400,000 into a property, that they would take at least some minor care with the 2 or 3 documents that need to be filed in the record to make sure they're done right. The records are a horrible mess, like in your case, Chris.
Well, that's what we were hoping the judge would take a look at, that the assignment, which came from a known robo-signer who's a loan officer for Wells Fargo, who signed the assignment document stating she was a resident of my home, would have looked at the document before she signed it to determine that the actual docket number of the mortgage was what was being assigned. So we're hoping that the judge can kind of grasp the fact that none of these people had personal knowledge of this loan. But my point is, if a couple of weeks ago you were talking with Mark in New York, I believe, and you were mentioning about the FDCPA and the actual ability for a servicer or credit or debt collector to take an assignment of mortgage while in default in order to render payment through foreclosure. Is that what I got from that conversation? Uh-oh. Did I lose you?
Oops, there you go. Yes. Okay. Yes, they have. They can do that. They can make that assignment. They have servicers that specialize in foreclosure. So generally, when a note gets slow pay, the first way you can tell by paying attention to the public record is you'll find an assignment. Because they'll assign it to this servicer that specializes in foreclosure. Well, if a servicer receives the assignment after a notice of acceleration has been filed, then that servicer cannot claim that he's acting to recover the collateral for the bank. He is a debt collector. If he receives the assignment before there's any foreclosure proceedings, he can claim that he's recovering property, the collateral for the bank, and he doesn't fall under the FDCPA. But once, if they get it while it's in after a notice of acceleration starts the foreclosure process. So if he receives it after the foreclosure process is initiated, he falls under. That makes sense?
Okay. Right, it does. And that's what they did in this case. They actually took the assignment while we were in bankruptcy after they gave us the Act 61 notice and accelerated the payment, which is my question is, if the judge were to sit and say that since they assigned themselves from a bank that's been closed since 2008, a mortgage, and they assigned themselves the wrong document, is he going to allow them to correct the document, or does it become a matter of... Oh,
that means that the plaintiff... Okay, wait, let me back up a step. Is there a action by the plaintiff? I mean, are you the plaintiff in the case at bar, or is the debt collector the plaintiff?
The debt collector is the plaintiff.
Good. If the debt collector did not have standing or legal capacity when the action was initiated, then once it's determined that he didn't have standing, the case must be dismissed because the court never had subject matter jurisdiction from the beginning, and that cannot ever be corrected. They'd have to start all over again.
Okay. So they would have to start over with an Act 6 notice, start the whole foreclosure process over.
Yes, and how is the statute of limitations on this one running?
Well, I think it's 6 years?
Look at part of when you file bankruptcy and an automatic stay went into place, that will toll the limitation, so that has to be taken out. The time they weren't allowed to foreclose doesn't count. So they need 16 years outside the automatic stay.
Okay, well, we're running up. That happens in about 6 months.
Okay, then you want to... if the judge throws them out of court, they're absolutely going to appeal, and they'll get you past that time limit.
Okay.
Wonderful. So that gives them one more. Whatever happened to the admonition against collecting a debt after it's been discharged?
I'm not sure what happened with that. They seem to be avoiding that issue. I think for some reason the judge happens to just be avoiding the whole bankruptcy issue that happened. Okay,
maybe I can answer my own question. You are addressing whether or not the assignment to this party was proper. That goes to subject matter jurisdiction and standing, and that must be addressed before anything else. If it gets ruled in their favor and says the yeah, they do have standing to invoke the subject matter jurisdiction of the court. Now now the issue of the prohibition will come into play, and that may be why that thing, if it's in the court, it's still in play.
Right.
Yeah, these guys really work at not proving standing, because generally they can't. So they may use up their own time. You're getting in a good position here. Even if the courts rule against them, now they're not going to get it done through the Court of Appeals before their time limit runs out.
Right. I'm hoping that that's what happens. I mean, if the judge allows them to correct a note, is that something he's not going to just say, okay, how can they get another correction if the bank that they got the assignment from is no longer in business?
Yeah, that's going to be an issue. Hang on. About to go to break. Randy Kelton, Rule of Law Radio. A call-in number, 512-646-1984. We'll be right back.
Easy.
Well, you know, karma's lurking around the corner. You better watch every step you take. And good and good will follow you. Yeah, Brother Jerry, sing reality.
Okay, we are back. Randy Kelton, Rule of Law Radio, and we're talking to Chris in Pennsylvania. Okay, Chris, it looks like you're in a good spot, and it looks like the court is actually paying attention to law. He's not just blowing things off. This request that they show why the case shouldn't be dismissed that's a pretty big deal. And they're going to have a hard time getting over that.
Right. I'm hoping that when it comes down to it, the judge also looks at the fact that, you know, the first assignment should have never happened because they took the assignment from Wachovia, who was out of business, using MERS as their nominee, and MERS can't be a nominee for someone who's not in business. So,
okay, do you have that argument before the court?
We do.
Oh, wonderful. There's one more argument that it came to me just a couple of weeks ago. I was working up a FDCPA action, and I referenced 15 U.S.C. 1692E. So this doesn't sound so complex. FDCPA is 15 U.S. Code 1692. It's that one statute. And you got A, B, C, D, E, F, G, and so forth. So we generally reference G, and that's the one that allows you to send a qualified written request. But E is the one that requires that all notices be, I forget exactly the terminology. It has to be clear and understandable, and the quality of the communication is measured by the standard of a least sophisticated consumer. So I was just going through that, and then I went back and looked at a section. I was looking to see if this particular mortgage had MERS listed in it, and I see that there's MERS is defined as the beneficiary. And I said, wait a minute. If I'm a least sophisticated consumer and I read this contract that the lender brought to me, this contract defines MERS as the beneficiary. So from a least sophisticated consumer perspective, it appears to me that the lender at closing caused the beneficial interest in the instrument to be transferred to MERS, because the lender defined MERS as the beneficiary, or named him as the beneficiary. And now later on in the contract, it says in the second paragraph of the contract itself, the first page and a half or 2 pages or so are definition section. The first paragraph of the contract is the transfer of the property. And that if it's a mortgage state, is Pennsylvania a mortgage state or deed of trust state, Chris?
It's a mortgage state.
Okay. Then the second part wouldn't matter, because the second part says the first paragraph in a deed of trust transfers the property to the trustee. In a mortgage, it'll transfer the property to the borrower. So that won't, in Pennsylvania, that argument second part of the argument won't matter. I know I'm confusing everybody. So let me explain a deed of trust first, and then I'll do a mortgage. The deed of trust says MERS is the beneficiary. Then the property is transferred to the trustee to hold in trust. That would be legal title. So beneficial title in the definition section was transferred to MERS. Legal title is transferred to the trustee. The very next paragraph starts with together with. And together with all improvements, it includes with the property as collateral any improvements to the property. Right in the middle of that paragraph, they stuck this sentence in there that says, you understand MERS is not the beneficiary, but merely holds legal title. Now, okay, so they hold legal title. But how can they, now they're not the beneficiary. So either they are the beneficiary or they're not the beneficiary. I'm a least sophisticated consumer. I don't know what to make of that. I don't know who the beneficiary is. It appears as though MERS is the beneficiary because I transferred it to it. So when MERS subsequently transfers beneficial interest from the lender to someone else, I'm going to say MERS transferred the interest that the lender held to this other party. But the interest that the lender held was nothing because MERS held the beneficial interest, not the lender, according to my contract. And if they're going to say, oh, well, that's not really the case, then I'm going to say, then your contract is too ambiguous to be enforceable. I'm not the one that put that crazy language in there. You guys were. And in a mortgage contract, in a Fannie Mae Freddie Mac uniform instrument with MERS, even a mortgage contract has that same language in there. The difference between a deed of trust and a mortgage is the property is not transferred to a trustee. The trustee section's not there. It's transferred to the lender. And where MERS is named in the contract, it's transferred to MERS and not the lender. Mortgage is a little different. I probably shouldn't have brought that up, but it is a good argument to maintain that MERS held a beneficial interest. So they didn't transfer the beneficial interest that MERS held. They transferred the beneficial interest that the lender held, which was no beneficial interest. Does that make sense, Chris?
That makes sense. That makes sense. If MERS is even an active nominee because the bank has been closed, that's the part we didn't understand with the first assignment, that even if you look at it, it's a fallacy of relevance because there is no nominee status to a bank that's closed. And if you look at MERS membership online, it even shows the banks who are members of MERS, and Wachovia is not one of them and hasn't been since 2009.
And you might consider complex equivalent. Have you heard me address that before? Nominee is a complex equivalence in that nominee has a meaning. When you hear the word nominee, you think of the Webster definition, or you think of the Black's Law definition. Well, they happen to be the same. And how they define a nominee is someone who has been named for consideration to a position. But the way nominee is used in the deed of trust, clearly that definition doesn't apply because it would mean nothing. You would state in the definition section that MERS has been nominated to be an agent for the lender, but it doesn't name MERS as an agent for the lender. But on reading the contract, it appears that the lender who created that contract intended that MERS actually be an agent. But they didn't call him an agent, they called him a nominee. So that term turns out to be a complex equivalent in that you have one meaning for the term, and I'll have a meaning for the term, and our meanings will be the same, Webster's or Black's. But the bank has a different meaning for the term, and they didn't define that meaning. So we have two different meanings for the same term. That's a complex equivalent, and it renders the document ambiguous to the point of being unenforceable. I don't know who wrote that contract, but they had to be high on coke. Only a lawyer could have written something that stupid, and he had to be high on coke to get it quite that stupid. it took me several years to allow myself to say, this is crazy. Because if you go look on Fannie Mae Freddie Mac's website, you've got a list of all of these documents. Every state is using this form. 50 states are all using this form. So I read it, and it doesn't make sense to me, and I'm thinking, I must have missed something. But it took 3 or 4 years of research to realize I didn't miss anything. This deed of trust and mortgage, Fannie Mae Freddie Mac uniform instrument, is nonsense. A 10th grader wouldn't have made these stupid mistakes. There's nobody that can enforce this trash. Anyway, enough of my ranting about that. Just a couple more arguments you could certainly make, but Chris, I don't think you're going to need them. It certainly sounds like this judge grasped, this is a real easy concept to grasp. You have a claim under a mortgage that's or under a loan that's been paid off. Good luck with that.
Right.
Okay, do you have anything else for us?
No, that was my question. Do you think if it comes down to the point where the judge allows the bank to render another mortgage and goes through the foreclosure process again, is it something that the FDCPA would benefit me making that argument up front? Because they're obviously a debt collector, and now they're attempting,
Okay, hang on. We're about to go to break. We'll finish this up on the other side. Mark, I see you there. We will get to you. Randy Kelton, Rule of Law Radio. A call-in number, 512-646-1984. We'll be right back.